5, 4, 3, 2, 1. It was also contended on behalf of the appellant herein that Bhavani was a member of the Employees Provident Fund and Family Pension Scheme 1971, and according to the records of the appellant, she had attained the age of 60 years in 1992 before the Employees Pension Scheme Act 1995 came into operation. Before the district forum, it was the case of the appellant herein that the said Employees Pension Scheme 1995 contained a cut-off date, and those members of the scheme who had attained the age of 60 years prior to the cut-off date were not entitled to the benefits thereof. It was the further case of the appellant before the district forum that, according to the records maintained by the office of the appellant, the date of birth of Bhavani had been shown as 24/9/1932. It was submitted that Form 2, which was required to be filled up and filed by the concerned employee while applying for membership of the Family Pension Fund Scheme 1971, showed her date of birth as 24/9/1932. It was contended that, according to the information provided by Bhavani herself, she had attained the age of 60 years on 24/9/1992 and was not therefore entitled to the benefits of the 1995 Employees Pension Scheme. Dr. Padia then went on to submit that the order of the National Commission under challenge was very cryptic and did not indicate reasons for negating the claim of the respondents in the appeals and deserved to be remanded to enable the National Commission to pass a properly reasoned order. It was then urged that any event this court had deprecated the practice of the employee approaching the management at the fag end of their careers, asking that their dates of birth be altered to their advantage. It was submitted that such a claim after the attainment of superannuation was all the more inadmissible, and the order passed by the district forum, which was upheld up to the National Commission to direct the appellant herein to correct its records relating to the date of birth of the respondent, was erroneous and could not be sustained. In this regard, various decisions of this court were referred to by Dr. Padia in support of his contention that contract of personal service or a service rendered free of charge would not agree the provisions of the Act 1986. Dr. Padia urged that the services rendered by the appellant to the respondent amounted to personal service which was of a free nature and would not therefore attract the provisions of the Consumer Protection Act on both counts. According to Dr. Padia, the respondent could at best have asked for pensionary benefits under the 1971 Employees Family Pension Scheme, which had been replaced by the Employees Pension Scheme 1995. The district forum had no jurisdiction under the Consumer Protection Act to direct alteration of the date of birth of a member which was recorded in the records of the appellant.